settlement system, right? And the question was, how does the WTO cater for least developed countries, right? Is the system working for everyone? You've got big powers in the WTO, for example, the United States, the Japans, you know, what you call the first world countries. And of course, you've got some of the least developed countries on the planet, you know, and most of them are found on our continent. So the issues of adjudication of disputes and so forth is a very important tool that can really assist us in any given environment to circumvent problems, but to make sure that when they do arise, we actually have, you know, institutions that can adjudicate and make sure that we are able to resolve our issues. Now, every time you talk about adjudication, there's a number of issues that come into play, right? In a normal, you know, litigation environment, you know, there's a dispute between the party issues summons, and then of course, the matter eventually ends before a judge, who will then make a decision. And of course, judges can get it wrong, so people can then appeal and make sure that you know, they get a different outcome, or sometimes those outcomes are confirmed. So that's purely at a domestic, human-to-human level. Now, if you take that and you now put it at state level, it becomes even more complicated, because you have nationalities, you have, you know, histories between these nations, and, you know, history of the continent as well. So there's a lot of sensitivities and challenges that come into play. Now, every agreement is to ensure be able to resolve. The Africa Continental Free Trade Area Agreement also makes provision for that. It makes provision that there will be disputes between the parties, and if there are disputes, how those disputes should be dealt with. So today, that's what we're going to deal with. We want to understand the framework of this agreement so that going forward, we are in a position to ensure that we understand what we're dealing with. So, Khulufelo Kugla, Ms. Khulufelo Kugla, thank you very much for joining us. I'm going to give you the opportunity to just introduce yourself.
Okay, thank you very much.
And once
Ronnie,
we're done with that, we're then going to enter into it. Thank you.
Okay, thanks a lot. Thank you very much, Ronnie, for the kind invitation, and thanks to you all for tuning in to this discussion, which I think is very important, and I think is also very timely. As Ronnie said, the agreement has come into force, and of course there is a dispute settlement chapter to the AfCFTA agreement. Now, my intervention will be more focused on the lessons that we can learn from the WTO's, I would say, mistakes and maybe shortcomings. I will discuss what has happened in the dispute settlement mechanism of the WTO, especially the appellate body, and then also look at the AfCFTA agreement itself and see if there are any mistakes that have been avoided, and see if there are any similarities, and probably discuss some lessons to be learned. And after that, I would like to have a discussion with you all to get your views, because it's always great to get views from various people. I work in Geneva and I live in Switzerland, and my world is very narrow and sort of focused on the trade community. But it's always, of course, interesting to hear other views. But before I get ahead of myself, let me just quickly introduce myself and my background and what I do. So as I've already said, my name is Khulufelo Kugla, and I'm an international trade lawyer. I work at the Advisory Center on WTO law, and that is an international organization that's based in Geneva in Switzerland. And we provide dispute settlement support. We provide legal opinions or legal advice, and also training to developing country members and least developed countries. So there are about 76 countries right now that are eligible for our services, and least developed countries do not have to pay for our services, especially providing legal advice and training. We do charge our members a little bit for disputes, but in comparison to what they would be paying on the commercial market, it's just about a drop in the ocean. My background is in law. I have a BA in International Studies and Economics, actually, from UNISA. and I did my LLB at the University of the Witwatersrand. And I studied my master's degree at the World Trade Institute here in Bern in Switzerland. And I've been living and working in Switzerland and studying since 2013. So it's really a joy for me and a pleasure and a privilege to be speaking to you as I see everybody, or just about everybody's on the African continent, especially speaking about topics that are dearest to me, Africa and trade. So I look forward to a really interesting and interactive discussion on these very important issues. Thank you very much, Ronnie.
For your introductions, and wow, congratulations on everything you have achieved so far. It's always great to see people from our continent leading the spotlight in some of these important decisions that we have to take. But now tell me, since you are involved in assisting least developed countries, right, in dispute proceedings at the WTO, what has your experience been? What is mainly the challenge, outside of capacity issues and so forth? What has been the challenges for these countries? And this is important because what I sort of want to do is build, a foundation, also to show in terms of international law generally, in terms of, how it applies in given circumstances. So what has your experience been in terms of the LDCs in that regard?
I mean, as you may be aware, or as you know, there hasn't yet been an actual dispute that has gone to the panel stage or to the dispute resolution phase involving an LDC. There's one that was initiated by Bangladesh against India, but this one ended at the consultation phase. So right there, you begin to see that LDCs in themselves do not participate really at the dispute settlement mechanism for various reasons, right? It could be that they have a comparatively low percentage of trade. Most of the trade is under preference schemes. So the markets that they're interested in, they have duty-free, quota-free anyway. And so for them, it just seems like there isn't any reason to have a dispute. And when they do have a dispute, it is solved in other means and not through the dispute settlement system. It is solved diplomatically. And I mean, when we're moving from LDCs to developing countries, then we see a little bit more sort of range and diversity of issues and reasons. I would say generally developing countries do participate, but the developing countries that have not been able to participate are those on the African continent. And that's for various reasons. And it could be that there is lack of coordination between capital and the mission at the in Geneva. It could be that some African countries do not engage in disputes as a means to resolve their issues. They rather, engage in diplomatic and sort of negotiated settlements. So, but interestingly enough, African countries have been increasingly becoming involved as third parties in disputes. But just sort of to modulate my answer, the African countries that have been involved actually have been in the north. So Morocco and Tunisia have been and are currently involved in the first Africa to Africa disputes at the WTO. I'm very sorry for not including that part of Africa because it's definitely part of Africa, but sub-Saharan Africa has not been involved, at the panel level or beyond the panel level as well. So there is increasing interest from African countries getting involved as third parties. And for many countries, that's a way to learn the system and to navigate the rules without being on the spotlight. And I think, in years to come, there could be, an awakening of African countries, especially from sub-Saharan region, to get involved in disputes as main parties.
Oh, great. Okay, thank you so much. Now, in my introduction, I tried to give some examples of what could happen in international. So I don't know if you know this, Kulu, and if you do, maybe you could expand on it. But just shortly after the American Civil War, there was a lot of tug around land and who should own what. As you remember, there's a group of people who went overseas and went and settled in America, so to speak. So one of the major cases that set some international precedent was a case between the state of Pennsylvania and the state of Baltimore. So what had happened there is that they were both lords, Lord Penn and Lord Baltimore. And they had some dispute between them relating to the ownership of the land in America and so forth. So what happened in that case is that the British courts spoke about a very important element of law, which is relating to enforcement. That says once you make a ruling as a court, you cannot just make it for fun. There has to be, the possibility of enforcement of that ruling. And the court literally decided not to make a ruling on the matter because it was going to be very difficult to enforce the ruling because one of these gentlemen already had all his property in the States, and therefore they wouldn't have, the legal powers or so to attach, etc. But there's also, on the example I gave on sensitivity, I don't know if you guys know this, but in SADC, we have what we call a tribunal. SADC is also a form of, a trading zone in our region. And there's a tribunal there. And previously, what could happen in the tribunal is that, both individuals and companies could appear before the tribunal for trade disputes or any form of dispute between the members. And the issue in Zimbabwe about the land invasions was taken to this tribunal for adjudication. And the tribunal agreed with the farmers. This, you can imagine, created a lot of discomfort in the region, to a point that since that day, the tribunal literally ceased to exist. So you can imagine how political this can be. But now, I would like you, Kulu, thank you for your generous introduction, but just to take us through what you have for us today. You will basically be telling us the lessons learned from the WTO. And colleagues, there's a reason behind this. Currently the DSB in the WTO is in a state of paralysis. There's unhappiness by the United States, and therefore the organization is in limbo, so to speak, to a point that you've got other blogs creating their sort of independent alternative mediation outside of the WTO. So this is important for us because I think, as Kulufelo said, countries. Okay, let me just leave it to her to explain it, and then we'll take it from there. Kulufelo, thank you so much. You may proceed with your presentation.
I'm quite happy to hand over to you, Roddy, to take this on. Okay, all right. Can you all see my screen?
Maybe, before you even get here, let's do it this way. Né?
Okay.
Let's assume that most of our members, do not really understand the international trading environment, especially from a dispute point of view. So maybe just give a high-level overview of how the system works within the WTO, and then flowing from that, you then just sort of dive into it from there. Thank you so much.
Okay, it's my pleasure, and I think it's very important for this specific presentation. So basically, as Ronnie has mentioned, the WTO has rules, and these rules are enforceable. And there is a treaty or a chapter, a dispute settlement chapter, if you will, in FTA talk that sets out the procedural rules, and this is called the DSU. And now in this, agreement, it sets out the manner in which disputes will be resolved at the WTO. So at the first instance, the party that has a problem will request consultations with the other party. Then this was sort of a non, I guess, conflict, means of dispute resolution that is not very conflictuous, I guess. And then it's alternative dispute resolution means. And after consultations, if the parties still haven't resolved their disputes in a peaceful manner, they can go to the panel process. And this is usually 3 people that sit on the panel, and they will decide the dispute. If the dispute is not resolved at the panel level, one of the parties or both can appeal to what is called the appellate body. And actually my presentation will focus very much on this body, which is the Court of Appeal, the Standing Court of Appeal, if you want to call it that way, a quasi-tribunal at the WTO, and it also gives its opinion or judgment after that. And after that, the report is adopted by all the members. And then there's a period of implementation. So in that period of implementation, the party that has to comply with the ruling is given a certain amount of time to do so, a reasonable period of time. And after that time, if they haven't complied, then we go through steps that could be, for example, the other party can retaliate. So what is important to note under WTO law is that there is no sort of costs given or damages. The ultimate means of compliance is actually complying, fixing your measure so it's compliant with WTO law. So this is basically the steps. I mean, obviously there's other sort of consideration that go into that, but this is just basically the high level overview of what happens in a dispute. And the compliance rate is very high, actually. About 90% of all panel and appellate body reports are complied with. Very few have not. I think what's interesting about the system is that it's the most prolific state-to-state dispute settlement system in the world right now. It's also one of the youngest. There's almost 600 disputes that have been initiated thus far. And I think what I'm going to talk about will show you how, what's going on, or the situation right now is affecting, this dispute settlement system that is called the crown and the jewel of the WTO. It's something that, WTO members are very, very proud of because it's really effective and, the only one in the world that has, enforceable rules that, members can get something out of a court judgment. So without any further ado, let me just go into my presentation. So feel free to sort of ask questions. What we'll do is we'll have a discussion at the end, but if you do have questions, maybe, you can already write them and then we can start collecting them. But I think what I would like really is to have a really sort of in-depth conversation with you and to get your views on these issues and how you think, they apply to us, in the AfCFTA context, or whether they don't at all. So that is it. Let me just start the presentation. Okay. Sorry. My IT skills sometimes.
They betray us at the best of times, Philip.
I know. Well, I mean, we already know what the name of the presentation is about. It's basically seeing what the AfCFTA can learn from the WTO dispute settlement system. And we will be going through, I guess, two major agenda items and then a little bit of discussion in the end about the MPIA, which is the multi-party interim arbitration appeal arrangement, which is what Ronnie alluded to earlier about members that have tried to, go around the problems right now. And then in the end, just a little, some discussion with all of you about what we're going to talk about today. Now, the appellate body crisis, and before I go into what happened, I think it's very important to set out the, the lay of the land and to see what the rules are. And for those who are not lawyers, I'm very sorry, but this is very important to our discussion today, and I'll try not to read everything, but sort of explain to you the, the main concepts here. So basically, as I have explained, the WTO has a standing appellate body. The panel system is not a standing body, but it's ad hoc. So panelists are appointed per dispute. In the WTO, the appellate body is a standing appellate body that is established by the dispute settlement body. So this is sort of the political body that goes, on top of the judicial function, the WTO body of the appellate body, and it's composed of 7 members, and 3 of them form the quorum or division. So every case is heard by 3 members, and there's 7 in total. Now, they are appointed for a 4-year term, which is renewed or renewable once. And according to Article 17.2 of the DSU, vacancies are filled as they arise. And this is very important for this discussion. Now, I just want to give you the background of what's happened, sort of a chronology that leads you to the United States problem with the system, and that sort of kind of shows you and leads you through what has happened and why are we here, basically. So this goes back to December 2016, where the chair of the DSB, the Dispute Settlement Body, so the political body that is, you know, higher up the hierarchy from the judicial function, which is the panel and the appellate body, they announced that one of the terms of the appellate body members, actually two, would expire. So one would expire on the 30th of June 2017 and the other on the 11th of December 2017. And this is when the DSB launched the appointment process. So if you are aware, the WTO is actually, you know, going through the DG appointment process. So this is very similar, but except it's obviously the appellate body members are appointed by the DSB and not, you know, the whole membership, but it's very similar in that way. And actually, this was in December 2016, and in May 2017, the US actually went ahead and blocked the initiation of the process for Professor Van den Bosch's pending vacancy. As you know, his vacancy would, or his contract would expire on the 11th of December 2017, and the US was saying this is just too far. Let's deal with Mr. Ramirez's appointment first, and then we'll go to Professor Van den Bosch. And the US was saying this is because it was going through a period of transition. They just appointed Lighthizer, who is the US trade representative. And as you can see, it was very early in Trump's term. And so on the 30th of June, indeed, the second term of Mr. Ramirez expires. And this is the first WTO member whose term is expired. So now the appellate body member whose term is expired, now the AB only has 6 members. On the 1st of August, the Korean AB member, Mr. Kim, tendered his immediate resignation to the chair of the appellate body, who at that time was Ambassador Bhatia from India. And the reason for this was that Mr. Kim had been appointed as the trade minister of Korea. And according to the rules, appellate body members may not be affiliated to any member government. So there would be a direct conflict if Mr. Kim had continued his tenure at appellate body. So as of the 1st of August, there were 5 members left. Now, I mean, this was an ongoing process. It's not something that happened overnight. And I think what's important, or what's interesting for us to note at this stage, that in 2017, the chair of the DSB was actually Ambassador Xavier Karim from South Africa. So he was very much involved in, you know, everything that was happening. And so there was definitely sort of a strong African link in what was happening at the time. And obviously he was trying to mediate the situation. But officially, the US came out and blocked the appellate body appointment selection process on the 31st of August 2017, where they stood up and they said that they could not continue with this process because there are systemic concerns that they have been raising for a long time, basically since the Bush era. And because of that, on the 11th of December 2017, Professor Van den Bosch's term expires. On the 30th of September 2018, the first term of the Mauritian appellate body member, Ambassador Sevan Singh, expires. And now we're down to 3 members, basically. And at this stage, as you can remember, 3 members is the quorum, right? This is the division. This is the minimum number that the appellate body can operate on. And it was a very dire time at this stage. And so they launched what was the special session, which was chaired by Ambassador Walker of New Zealand. Actually, he was the DSB chair now he's the chair of the General Council. So that is not correct. And in December 2019, so last December, the second terms of 2 of the 3 members expired. So this is Ambassador Bhatia of India and Mr. Thomas Graham of the US. And currently the AB is composed of 1 member, who is Dr. Zhao of China, and she will be the only member until the 30th of December 2020. So this is just sort of visually what I was telling you, you know, over the course of 2 years, what has happened to the appellate body. And so what I'm going to do right now is just tell you the reasons that the US, so the 5 main reasons, I think there are many reasons, and US has definitely, you know, has an arsenal of complaints, but you know, if you go through all of the statements, what's really good about the US is in all of its complaints is that it's an administration that is very transparent. So if you wanted, you can go on the WTO missions website of the US and see every single statement that the US has made, not only throughout this time, but you know, for quite a long time. And so this is what the US, you know, used to say at every single DSB meeting, and the DSB met or meets at least once a month. So the first problem that the US had was this issue of Rule 15, and Rule 15 refers to Rule 15 of the Working Procedures for Appellate Review. So the working procedures specifically for appeals. And basically what this states is that the appellate body can authorize an appellate body member whose term has completed or whose contract has expired, and notify the DSB that this person will stay on longer to complete a case. I mean, obviously this is necessary because it's not ideal to have a member or a judge to, you know, to resign or his term to expire while he or she is completing a case. So it's very much for practical reason, but I think the issue here was that the authorization comes from the appellate body and there is notification given to the DSB. And as I said to you before, the hierarchy is like this: DSB here and appellate body here. So this was the issue that the US said, because, and the US was saying, well, according to Article 17.2 that I showed to you before, appellate body members may only serve 2 4-year terms. So to the extent that appellate body member is serving a term that's longer than 8 years, that is a problem. The second issue, so remember it's 1 of 5 that the US highlighted, was this issue that's called the 90-day rule. Now, according to Article 17.5 of the DSU, the maximum period in which an appeal should be decided and an appeal and a report issued is 90 days maximum. So, you know, ideally within 60 days, but in no case it should not exceed 90 days. And if the appellate body thinks it's going to exceed 90 days, it should inform the DSB with reasons for the delay. Now, the US was taking issue with the fact that this happened as a matter of course. You know, very few cases, if I remember properly, the last case that was completed in 90 days was in 2014. And it's not all because, it's not all the, you know, the appellate body's fault, let's be honest. I mean, the appellate body is now looking at an appeal rate of about 70%. So 70% of all panel reports are appealed. The issues have become more and more complex. We have, you know, the aircraft cases, Boeing and Airbus, that go on for years and years. You know, cases are becoming more complex. Members are writing longer submissions. There are more sort of interim, you know, procedural points that are raised. And of course, the system is not going to function in 90 days. But you know, the US took issue with the fact that, you know, we signed up for 90 days, but we're seeing disputes that are going on for 2 years, you know, at the appeal stage. The third issue was the review of facts, including members' domestic law. So according to the US, it stated that, you know, appeals should be limited to points of law. At the appeal stage is not any stage to be reviewing facts. We all know that in domestic legal systems. And so the US took specific issue with the fact that the appellate body sometimes tries to interpret its domestic law, which in international law should be an issue of fact and not an issue of law. And this is specifically, that goes back to the US's anti-dumping legislation, and in which basically the WTO stated that US anti-dumping law is not consistent with WTO rules, and US took, you know, umbrage to this, and it has a really, you know, big issue with these rulings. So issue number 4 of 5 is that the US said that the appellate body issued advisory opinions. And basically, when you look at the DSU, you have statements like the aim of the dispute settlement mechanism is to secure a positive solution to a dispute, and the appellate body shall only address the issues in accordance with basically the issues of law, and should not be making any judgments or any decisions on anything beyond what is necessary to resolve a dispute. And so the US said the appellate body was engaging in what we call obiter dicta, so basic, by the way statements, proclaiming on issues of law that weren't really brought by the parties. And the US was saying this is going beyond the mandate of the appellate body. And the final issue here is the issue of precedent. And I think for most of us in this session, most of us come from common law countries where precedent or stare decisis is something that is, a matter of law. Judgments are law. And as you may know, sorry? Oh, okay, I'm going to continue. So there was just some disturbance. As we know, under common law systems, judgments and decisions are law, and that's it. But under international law, cases actually only apply as in between the parties, and they do not bind any parties that are not main parties to the dispute, including the third parties, of course. And the US took issue with the fact that there was a quasi-precedent system that was developed in the WTO, and the US said that the GSU says that the DSP cannot add or diminish the rights and obligations provided in the covered agreements. Basically, you can't give more or less than is what is provided in WTO law. And members cannot be bound by decisions that they're not parties to. An appellate body in a case famously said that, absent cogent reason, absent really important and grave reasons, the appellate body or any adjudicatory body will resolve the same legal question in the same way in a subsequent case, which for all of us makes sense because it's all about legitimate expectations, right? If you get a case with the same type of facts and the same type of violation, you expect that it's going to be resolved in the same way. But the US, took issue with this, and I mean, obviously, I'm speaking in my own capacity, and what I'm saying is not a reflection of what my organization, holds in this matter. But I think, especially for this one, it's difficult. It's difficult to see an issue with, legal certainty. If you get a case that looks one way and that's decided a completely different way, unless if it was decided, in a wrong manner to begin with. But for legal certainty, I think it's very important that cases are resolved, or like cases are resolved in a similar manner. But this was an issue. Now, you can imagine there were many proposals, sort of members bending over backwards trying to resolve the impending crisis. And the US basically, if you can go through its statements on its website, the WTO mission website, it basically repeated more or less the same thing every single GSP meeting. There was no engagement from the US. I think members to this day don't know what the US wants, but they know what the US doesn't want. And there was some, convergence of the proposals, of the many proposals that some members brought forward, and Ambassador Walker actually consolidated them. And right now, there's, sort of on this, as you can see on the slide, they've been consolidated to the following points. With the Rule 15 issue, they said, well, let's, automatically fill the vacancies as they arise. And the outgoing member may only continue, sorry about that. The outgoing member only continue if the hearing is held before the term expires, which is basically what was done anyway, what is done anyway. The 90-day deadline, there has to be, explicit consent of the parties to go beyond the 90 days. Municipal law shall be treated as a question of fact and not subject to appeal, which is basically the status under international law. For advisory opinion, the member said, well, the AB must only address the parties that are raised and that are necessary. Precedent, basically saying there is no precedent created by prior reports but prior reports may be taken into account where relevant. And the issue of overreach, basically saying panels in the appellate body may not add or diminish to the rights and obligations of members. And they also have to apply a special standard of review in anti-dumping cases, which is basically, the bulk of the US's issues with the appellate body or with the dispute settlement system in general, and regular, I guess, engagement between the DSB and the judiciary, I guess the judicial function or the quasi-judicial function, meaning that of panels and especially the appellate body with the DSB to meet and to discuss issues of mutual interest. Now, this basically in a nutshell is what happened and what are the main issues that the US expressed. And just to sort of, step back from US blaming, to be fair, the US was not the only member that had issues. The US was just that member that voiced them out loud. So there were definitely some members that shared the US's sentiments that this is not working, but the US decided to sort of, be the Robin Hood and represent, the people that didn't want to speak for themselves. So this sort of concludes the WTO part, and sort of trying or starting to implement this wonderful agreement that we've negotiated as a continent. There are definite lessons to be learned from what happened at the WTO, especially since the AfCFTA dispute settlement protocol looks so much like the DSU. I mean, just going through it, I felt very much at ease, very much at home with, the provisions that are written there. I mean, not to say it's a copy and paste, it's not, but it's a definite sort of strong influence, if I would say it, But, there's everything that's in the DSU, you will find it in some way, shape, or form in the AfCFTA dispute settlement protocol, including the fact that there's a dispute settlement body, including the fact that there's a panel system and a standing appellate body, and the standing appellate body has 7 members and 3 of them form the division or a quorum. The system of consultations, the system of panels, the system of the appellate body, and the implementation phase, there's so many similarities between the two agreements that, of course, it's best and we should be warned and take some lessons from what happened at the WTO. So I'm just going to sort of pick out a few things and then we can have our discussion after that. So the first thing that I would like to congratulate us is that, it's not by accident that some of these things happen, because, the agreement was being negotiated during this whole issue, during this whole problem at the WTO. And I think somebody rightly looked at the issue, at the problems and said, whoa, we need to come up with a solution so we're not trapped like the appellate body of the WTO is trapped. And so I beg your pardon. So basically, Article 20 of the dispute settlement protocol states it's very similar, as you can see, to Article 17.1 and Article 17.2 of the DSU, but it states that the DSB, again, will appoint the persons to serve on the appellate body for a 4-year term, and each person may be reappointed once. This is basically the same. Vacancies shall be filled as they arise. This is basically the same. But now here's the innovation, which I think is a lesson learned already. The DSB shall appoint a person to fill the vacancy within 2 months from the date of the vacancy arising. This is not in the DSU for obvious reasons, and I think this was added for obvious reasons. But this is even better. Where the DSB fails to appoint a person to fill the vacancy within 2 months, the chairperson of the DSB, consulting with the Secretariat, shall within 1 month of that fill the position. So there's clear power given to the chair of the DSB if things go completely kaput, as they say in German, to appoint appellate body members. Then in this way, the AfCFTA dispute settlement system will never be in the situation that the appellate body is in right now. So this is, I think, a big plus so far, lesson learned already. That we see in the AfCFTA. Now I'm going into the possible lessons to be learned. So this is lessons that we can still learn. Now, in the AfCFTA, the normal panel process should be completed in 5 months, but may not exceed 9 months. And in the AfCFTA, again, the appeal stage should not exceed 90 days. And as we saw, remember the whole 90 days issue, this might be a problem. And I mean, let's even step back a little bit. As I said before, we don't know to what extent this mechanism will be used, because as Ronnie alluded to earlier, African countries have not used, state-to-state dispute settlement systems in the regional economic communities, and also very rarely at the WTO. So far, we have a system that is there, it's open for members to use, but we will see if it will be used. And therefore, we do not know if these timelines are realistic or not. But what I'm trying to propose here is, let's see what we can learn from other systems that have been used. So this is, I guess, sort of, in the background. We should always keep that in the background. How much will this system be used? Now, in comparison to the WTO, standard panel proceedings take approximately 554 days. So the requirement in Article 12 of the DSU is 9 months. And so standard panel process actually take double the amount that they're supposed to. And again, the 60-day issue, the standard appellate body proceedings take approximately 186 days, which is about 6 months, which is also double the 90 days that is required by Article 17 of the DSU. The reason why I say standard panel and standard AB proceedings is that the compliance phase, there's also a little sort of a small panel phase that comes, a small panel and appellate body phase when members discuss about whether another member has complied and have they complied fully. So that is also another panel and appellate body proceeding within the whole process. But the normal ones, before we go into the compliance phase, these are the timelines. So realistically, I don't know how realistic the AfCFTA dispute settlement protocol timelines are. As I said, this is subject to how the mechanism is going to be used, if at all. But if there are lessons to be learned, this is one of the lessons to be learned. Now, I'm sure you have all heard about the consensus rule at the WTO, and possibly in the light of, hearing that it doesn't work. It really doesn't work for everybody to agree to everything. And I don't know. I mean, I'm not going to sort of state my position here. It's either here nor there for me in this case, but I'm going to focus specifically on dispute processes. And I think this is very important because the WTO is actually, the DSU is an innovation of the GATT system. So the WTO learned from its mistakes during the GATT era and applied them to the dispute settlement understanding. And so under the GATT, all of the processes, whether it be during disputes or just negotiation, relied on consensus building as a means of making decisions. And now during the Uruguay round, this was changed. And in the WTO right now, the dispute settlement system, there are 3 decisions that are not taken by consensus, but they're taken by negative or reverse consensus, meaning that everybody has to agree to disagree. So, but that's never going to happen, right? Because if you want to establish a panel, the complainant is going to agree. The complainant is never going to block its own panel establishment. So it basically means that all of these steps are automatic because there will always be one person that is going to not agreement, to the decision. And so in the DSU, the 3, steps that are, taken by a negative consensus is the establishment of a panel, the adoption of reports, appellate body reports and panel reports, and the authorization for retaliation. Now, so my reading of the AfCFTA protocol, and I'm not a negotiator, so I did not negotiate this, and I know there's some people in this session that have negotiated this, and maybe they can shed some light when we have our discussions, is that, I see somebody has drawn on the screen, but anyway, is that the AfCFTA dispute settlement protocol only contemplates negative consensus rule to the adoption of reports and the authorization of retaliation. Now, but what happened to panel establishment? You know, it's great that, you know, there's automatic adoptions of reports and there's automatic authorization for retaliation, but that won't even happen if panels cannot be established automatically. So I don't know if this was an omission or if this was indeed intentional, but it's an oddity to me to see that establishment of a panel is not through reverse or negative consensus. And I mean, the default in the AfCFTA and in the dispute settlement protocol is consensus. And there are two instances that consensus or negative consensus is stated, and that's in the adoption of reports and authorization of retaliation. So for me, it was very odd to see that panel establishment wasn't singled out as one of the steps that must be decided through negative consensus, which, as I pointed out, might be a problem to begin with, to just get the panel to be established. Another issue that to be learned, a lesson to be learned, is that under Article 90 of the WTO, or the Marrakesh Agreement, members have the exclusive authority to adopt interpretations of WTO agreements. And in the Marrakesh Agreement, it says through a 75% majority. But obviously, as we all know, in WTO, the decision-making is through consensus. Article 10.2 of the AfCFTA basically copies and pastes this specific provision and states actually not 75% majority, but says through consensus. And so what is this? So these authoritative interpretations of WTO agreements can help the dispute settlement function, because maybe, and I think one of the biggest problems with the dispute settlement system of the WTO is that it is a, sorry, I see there's some chats. Okay, I see questions. I'll just, as I said, we'll go back to chatting at the end.
Yeah,
is that,
I think let's do that, Kulu. Yeah, thank you.
Is that okay? I'm almost done. I'm almost done anyway.
That's fine, thank you.
Is that, you know, the negotiating function of the WTO has basically been more or less defunct, I would say. The WTO has managed to get a trade facilitation agreement through in 2013 and has managed to adopt the amendment to the TRIPS agreement in 2017. But that's it, you know. But the appellate body and the panels have been booming. You know, it's been the most active international dispute settlement system in the world. Disputes haven't stopped coming. And of course, then it becomes almost that the judiciary, if we like to put it in domestic terms, becomes the lawmaker, which obviously, even in our own domestic legal systems, that cannot be. You know, we have elected officials that go to parliament that make the laws. It cannot be that the judges that are not elected in most jurisdictions by the people that are making the law. So obviously this mismatch has caused a lot of the problems that some of the members, including the United States, has raised. And so if the AfCFTA wants to maybe avoid some of these issues, is that the Assembly can be active in developing the authoritative interpretation of certain maybe ambiguous terms or certain things in the treaties. And in this way, we have a multilateral or a member-wide agreement on how terms should be interpreted, that when an issue goes to the dispute settlement system, you know, the judges know what to do, and they don't have to be guessing as to what the members intended and as to what was spoken about during the negotiating time. And so this is an obvious sort of open, you know, I think, way for the AfCFTA to innovate and to make sure that it doesn't import the problems that the WTO system has. Okay. I think this is one of the last issues that I sort of have in terms of lessons to be learned, is one of the things, and I think I pointed to this before, that the US and some members have, is it appeared that the appellate body may have been in some instances, you know, overstepping a bit. As I said to you before, it's the DSB here and the appellate body here. And the appellate body sometimes did not consult with its, you know, its masters, you know, and, you know, the bosses. And so I think a sort of a clear delineation of functions is something that, needs to be, made clear as to who runs the organization, who runs the AfCFTA, and who runs the dispute settlement function or the system of the AfCFTA. It would be the dispute settlement body. Of course, the judiciary and the panels and the appellate body would run, would play a very big and important role. But at the end of the day, they are accountable. And actually, Article 23 of both agreements say the DSB recommends. So although the appellate body and the panels, do all the work and they issue the decisions, the body that recommends and issues rulings is actually the DSB. So, this issue of hierarchy and making sure that, those roles are very clearly defined, I think will go a long way in avoiding some of the issues that we've seen at the WTO. Now, this actually concludes my presentation, or the main presentation. And I just wanted to say two things. I mean, I'm happy to discuss this further. The purpose of this discussion is not to talk about this MPIA, which is the alternative, arbitration and interim arbitration arrangement that has been concluded by 20 countries, including the EU and China. But the MPIA actually takes on some of these, issues that I said, some members have, come to, this convergence of proposals. And actually it talks, in the MPIA, there is a clause that talks about that, disputes or the appeals should be completed in 90 days. Except by consent of the parties. So, the arbitrators would have to first consult with the parties and say, this might be a problem. How do we resolve this? And there's even, a flexibility where the parties or the arbitrators can suggest actually shortening submissions or limiting the dispute to certain specific topics or issues. Right now, appeals, in my opinion, have become a sort of a machine gun approach. You just really appeal everything, and it doesn't really help the system if appeal submissions are just so broad and everything is appealed. So the MPIA, which is sort of the alternative to the appellate body under the arbitration provision of the DSU, takes on some of these lessons and tries to fix the system a bit. So that one came into force in April 2020, and right now they're in the process of appointing the arbitrators. So we'll see. I mean, obviously there's no case law yet, but I think it's sort of encouraging to see that there is at least some appetite for members to adopt some of these reforms that have been spoken about. And we don't know when the appellate body is going to come back to become fully functioning. It could be as quickly as whenever, next month, 2 months, whenever, whenever there's consensus about, the appointment process. But I'm sure and hopefully that we see some of these changes that members want to see, because ultimately this is a member-driven organization. And if, there's something that doesn't serve the members anymore, it's up to the members themselves to agree to change. And this concludes actually my presentation. So I'm going to stop sharing my screen.
A bucket full of helpful information, and I've been one of a mind, and maybe I'm going to start the question and answer session by sharing my devil's advocate side of things. And firstly, I'm very surprised by the screen right. It really surprises me as to what goes on there. I think many people are surprised. So I hope our IT director is seeing this and will advise me later as to what happened there. But look, based on what you just said, it looks like there is a lot of lessons that could be learned. And for me, I'm one guy that says if there's always a problem when when it comes to domestic law versus international law, multilateral instruments always have that type of challenge. There's issue of loyalties in terms of, different nations coming to the panels, politics, geopolitics, and so forth. The hierarchy you spoke about, and the fact that there'll always be, powerful nations and weaker nations. So, would I be, out of line if I suggested that perhaps we, follow, the MPIA example? Because I've seen recently that Brazil has, in their agreement with Mozambique, I think, many, sort of the trade agreements lately are doing this. Japan and the Philippines in their EPA as well have also opted to have this type of, non-aligned, for lack of a better word, structure. Do you think perhaps, that would be a better alternative as opposed to setting up a formal structure within the the AU for that matter, to adjudicate on these issues? I mean, considering that, we already have challenges in terms of caseloads and so forth in many of the jurisdictions on, in the continent. So would we not be overburdening the system if we're now also asking states to participate in something so technical as trade, and then maybe look more towards, the establishment of professional panels, perhaps on an as and when basis as required, and have these panels make decisions. And, for the next case, you'll set up another independent panel that will look into the facts of the matter and make a decision on that. Well, what's your take on that, Should we stay based on the experiences, stick to what we have? Of course, let's not be afraid, it is a cut and paste of the PSU. It actually says that it's based on, the dispute settlement protocols, I think, within the WTO itself. So it really is that. So do you think, what do you think of what I just said? And then colleagues, you may in the meantime start preparing your questions. And if you like, of course, we've already noted the ones that are being written. Thank you for that. And Kulu, yes, please, just to respond on that, then we may take questions then. Thank you so much.
Okay, so I think one of the important factors to remember about whether you're talking about the WTO dispute settlement system or you're talking about the AfCFTA dispute settlement system is power is decentralized in that it's not a power-based dispute settlement system. Now, once you leave it to individual states to sort of resolve their disputes without the support of an institution, it becomes sort of vulnerable to power politics. I mean, we see countries like Antigua and Barbuda taking on the US at the WTO dispute settlement system. If there was no WTO dispute settlement system, I highly doubt that a small, tiny country would be able to take the US to an independent arbitration and, expect the US to show up, first of all, And so I think in structures, and especially even in our continent where there's different power dynamics, taking those power dynamics out of disputes is very important. And I mean, the panel system already is ad hoc. So why don't we, bring those disputes to an institution where they're completely in trade disputes? I mean, trade is commercial interests, right? It's not about, it shouldn't be about politics, but at the end of the day, as we know, it's very susceptible. But I think once we leave it up to, member states to resolve in sort of, informal ways, we might be shortchanging our traders, actually.
Okay. All right. Okay. Thank you so much for that. The floor is open. I saw there's already some questions there. Can you see the questions as well?
Yes, yes, I can. So I will address the questions one by one. And okay, if I misinterpreted one, please feel free to correct me. So the first one is from Mishak. And he states that the WTO's main function is to ensure that trade flows as smoothly as possible. What are the legal challenges that the WTO faces and that makes it not achieve its goal? Is the decision of the WTO effective and whether WTO are prepared to comply? Yeah. So, I mean, I think the biggest challenge to the WTO right now is the problem of the appellate body. I don't think, there's legal challenges per se, but it's just the system is hobbling along right now. Look, I think I also, to also give you some sort of, I guess, comfort, is that members are still initiating disputes. That hasn't stopped. It has slowed down a bit, but it hasn't stopped. So it still shows that there is trust even in the panel system. So yes, it's not ideal. It's not working as it was before, but there's something happening. And I think the MPIA is also an indication of the trust that members have in the WTO system, because also the MPIA is basically a cut and paste of their appellate body procedural rules. Okay. So, I mean, members are not very creative, right? And as opposed as well as going to compliance and to the decisions that are made, as I said before, there's very high compliance rates. Members have been very good about complying when they get a judgment against them. So in that way, the WTO dispute settlement system has done its job. It's been able to issue judgments and rather very quickly. I mean, I think if you look at the timelines, let's be realistic. I mean, for a whole panel process to be completed in 9 months, I don't know about anybody's domestic legal system, but I doubt there's any case that goes to a high court that is completed within 9 months, really. Yeah. I don't know. And any appeal that is completed within 90 days, I don't know. So even though the timelines are, even the expanded timelines are still fast. I mean, I think you should also look at the ICJ's cases. The ICJ's cases take long, much longer than what the WTO does. So I think comparatively, the WTO hasn't been doing badly. I think the problem is that, members were saying, well, this is what the agreement says, and this is what we agreed to, and you appellate body and you panels are not complying to the agreement, which is fair enough. This is what was agreed to, but I think, putting into perspective and into context, it's not terrible, right? It could be much worse. The second question is also from Meshach. He says, how does the dispute settlement system of the WTO work, specifically with regards to implementation? And what does it mean to settle a dispute in a multilateral manner? Okay. Yeah. So I know I'm sort of ad-libbing a bit. If I misinterpreted, please do correct me, Meshach. Yeah. So implementation, as I stated to you before, after the member gets a panel report, so there's the respondent, if the respondent loses, they would have to comply either immediately, or they would have to agree on a period of time called the reasonable period of time to implement. So depending on what type of modification of laws or what kind of measure it has been, it could be something that's easy as issuing a decree or a regulation, or it could be a legal amendment of a law. It could take a long time. So the member would have to state, actually, I need 9 months or whatever, 12 months. To comply, and then in that time they have to comply. And as I stated to you before, if the member does not comply within that time, compliance, as I said to you before, is basically making sure that the measure is WTO consistent. So it's not about paying damages or anything like that. It's just basically amending the law so that it's not inconsistent with WTO law anymore. And if the member does not do that in the given period of time, the complaining member, so basically the winning member, can retaliate against the other member. And retaliation in this manner states, it's not, I guess in a sort of a violent way, but you can say, for example, well, if you don't let my apples through because you think that they have some sort of, apple blight disease or whatever, then I am going to apply, 300% tariffs on oranges or apples, or whatever. So it's basically a trade retaliation. That's the means of sort of getting back. The third question is, how does one write on your slides? I would like to. That's from Francisco Suka.
I think that's from Dr. Suka there. I saw that too. Yes. We have no idea, Doctor. We'll try and find out how that happens. Yeah.
Yes, I think we should really find out. Mr. Danny says, thank you very much, Mr. Danny Vengadesamy. I hope I said that right. Situmo says, thank you very much, Situmo. And then Faith says, excellent presentation. Thank you, Faith. And she says, as you stated very clearly, and also from personal observation, many African states do not use the WTO DSU and also the regional DSU. How likely will the states use the AfCFTA DSU to settle disputes? And as I said before, your guess is as good as mine. We will see. I think I wish I had a crystal ball, but I really don't. I don't know. And then there's a question from Professor Zucker again, who says, don't you think that African states will experience the same problem with potential judicial overreach? And she says, thank you for the talk. Sure, I mean, I don't know, you know, Dr. Professor Zucker, I mean, do we have, I mean, I'm really open to somebody, you know, educating me on regional dispute settlement systems that are not trade related, that I do not know much of. I mean, I know the human rights space is very active on the African continent. Do we have a problem of judicial overreach in those systems? I personally don't know. So I'm happy for somebody to engage us on that topic, if somebody knows how that works.
So this is a question, sorry, Kolo, but what is judicial overreach? So this is also a question, right? So
yeah, I mean, right, what is judicial? I mean, I guess, let me say, from the trade perspective in the US's, you know, sort of, you know, statement of what judicial overreach is basically a, you know, resolving issues that were not asked to be resolved. So basically going over and above the you know, the TOR, the terms of reference. So I don't know, Khaleesi, if you've got any input to that, but I mean, in the WTO, I mean, I can say from a panel report or appellate body report, you do see, you know, sometimes the appellate body says, in other instances, when you know, at the point where there's another instances, you're like, well, you were not really asked to talk about other instances, just talk about what's on the table.
But, sorry to respond to this.
Yes.
we always get frustrated as someone who's sort of interned at the appellate body and seen how the process works. And I think almost all judicial systems do this, where they sort of give an illustration to explain their reasoning, right? And sometimes members, and this is, so the times where we've added, or the appellate body has added a clause about, had this been X, Y, Z, this is how it have decided, is normally when they themselves, for example, there isn't an agreement on all members, or people see the reasoning differently, so you use an illustration.
Yeah.
I don't understand why people put so much weight in the illustration that's been utilized to drive it home.
I think the problem is that then, of course, when in a dispute subsequent to that, a member latches onto that and says, actually, the appellate body has stated that in instances that happen in this way, this is how we would resolve the issue. But in the previous case, that wasn't the issue at hand. You know, it was just an observation that was made. So I think that's the problem, that obviously, and I mean, to be fair, the United States itself does this, right? The US uses appellate body decisions to its advantage when it wants, as much as, I mean, the US is the #1 user of the system. So obviously for many years, the system served it, and it used the panel and the appellate body report to its heart's content. But obviously it's when, you know, those disputes that did not go in its favor, or the way that it thought should be interpreted, that was, you know, the point of no return for the US. But I mean, to be honest, your guess is as good as mine as where judicial overreach is concerned, what it is, and, you know, how it should be sort of managed. I guess we have to go to the point where really members go to the point of saying you only decide A, B, C, D, end of story. That's it. And when the appellate body report comes out and says on A, we say this, on B, we say that, and that's it.
But members
sorry, colleagues, sorry there. Firstly, can I just ask, we have about, 10 minutes or so remaining before we end our session. So I'm just going to ask whoever has a question, please kindly introduce yourself and before you ask your question. And Kulu, if you see the questions and you're willing to go, please just keep going, yeah?
Okay, I'm going to keep going, but hopefully maybe we can engage on this later. So there's a question from Jermaine, who says, how can the youth, especially those who have done international law, be involved to bridge the gap and also provide such informative sessions? I don't know what your interest is, but one thing that I always say to youth that are interested in these fields, I mean, international law is law, right? I mean, I was told when I was leaving commercial practice that international law is not law. And so I was told, what? You go to practice, what? But obviously there's a whole, I mean, I'm working in the field and I've got a job, right? So if you can, start with doing a master's degree and sort of capacitating yourself in that way, doing internships in organizations of interest, doing internship in African organization of interest as well. And I think, just being as skilled and as capable as possible. And I mean, obviously you can contribute not only in a government function, but also in many different functions, in private law firms and international organizations and African, regional bodies as well. So I think there's definitely a need for energy and for skill.
And as well, Kulu, there is going to actually be a huge need for more trade lawyers into the future, because if you think about it, you have to set up the tribunals. Firstly, that's going to adjudicate on tariffs and on trade remedies. At some point, that's going to be what happens. So I really think, and this is also what we're trying to achieve here, to make sure that we create a platform to make it easy, because it seems like so far-fetched at the moment. Oh, international trade, where do I start, But like you said, it's law like any other laws. Anybody can do it. No one was born knowing it. And the first step, I remember when I was at Tux, this course came out as, I think the name was called Transnational Business Law, which was extremely complicated. But that certainly did spark, an interest for me from that point of view. So clearly, and please do get in touch with us as well if you would like us to assist you in any other way to create a platform for young people to follow this profession as well. Now tell me, Kulu, I just want to get a bite from you. We spoke about, the reverse consensus, but what I want to know is, do you have, various, forms of mediation within the system itself? So can you have an arbitration, have a mediation, have a conciliation, and all of that? And
Yes.
Also, what recourse would the businessman have? Because now we're talking state to state, right? And that's, I mean, at a different level. So I think for most business people, that becomes the question to say, I'm a businessman, I'm invested in this country, I can't get out my money, or, the system is oppressive, or they're just not complying to, the concessions they've signed on. What do I do then? Can you also maybe just shed some light on that as well?
I mean, so for better or for worse, the dispute settlement system of the WTO, just like the AfCFTA, is state to state. And so the only way that business can really get the ear of the state is to be organized and to lobby. So, being close to decision makers and making sure that the industry itself is organized. I think one of the problems as well in African countries engaging and involving in dispute settlement at the WTO is that there's very few countries on the continent that have got, industry organizations that engage with government, that, make sure that government knows its problems, its concerns, and things like that. So once we, the industries get it organized, and once, there's sort of, I guess, multi-stakeholder, institutions where everybody can discuss and bring their grievances, that's when businesses will be served. And I mean, the WTO system works. It's worked for the US businesses, it works for the EU businesses, it worked for Japanese businesses, it worked for Chinese businesses, it works for Indian and Brazilian and Canadian. So just because it's a state-to-state dispute settlement system doesn't mean that businesses are completely out in the cold. No, businesses are very active. In the tobacco cases, the tobacco industry funded the cases for the government. So I think businesses just have to be really organized and engaged with the state in order to make sure that their interests are represented in disputes.
Okay.
So there is a question here. I'm sorry. Sorry for interfering.
Okay, go for it, sir.
Yeah, actually, so my questions are actually twofold. Number one, as you may recall, well, my name is Abraham anyway, and I'm pretty sure that Ms. Kola know me very well, but yeah, for the rest of the other people, I'm actually doing a master's degree in international trade law in South Africa at the University of the Western Cape.
Oh,
now,
great.
To my question, so as Ms. Kolo rightly pointed out, so if you look at the the entire problem now with the appellate body and the USA, for example. So one of the main contentions of the USA has to do with the report that comes from the appellate body after the appellate body has passed the 90-day the 90-day that was actually allocated for the report to be submitted. Now, according to the USA, once the 90-day expires, the decision must not, or the report must not be adopted on a negative consensus basis anymore. In other words, the report has to be on a positive consensus, which means all parties must say yes before the decision is adopted. Now, in respect to the AfCFTA agreement, I realized that you actually spoke about the negative consensus, and I'm not really sure whether the AfTA agreement or how does AfTA addresses that, since AfTA actually says 9 months. Like, let's assume the report of the appellate body takes longer than 9 months. What is going to be the legal effect of that? Is it going to be adopted on negative consensus basis, or is it going to be adopted on a positive consensus basis? That's the first thing. Now, the second question has to do with the fact that, again, on the panel establishment, as you rightly mentioned, under the AfTA agreement, it is based on what? On the positive consensus basis, unlike in the WTO. Now, if you look at this actually gives, the possibility of the panel not even being established at all, because positive consensus, as we have seen, is actually very difficult to achieve. But if we just put the panel aside, if you look at the appellate, but let's say if it's in the case of the appellate body, then one country or one member state, for whatever reason, it might not be the same reason as what we are seeing now in the WTO, but it might be for any reason, and then one African state decides that they are not going to, give their vote in terms of establishing the appellate body. Then the appellate body is effectively not functioning. So under Article 27 of the AfTA Dispute Settlement Agreement, we see that it actually calls for the establishment of the possibility of arbitration as one of the recourse that litigating parties may actually have. So my question is, what form of agreement do you think is going to be effective in respect to this Article 27? Do you think something ex ante or ex post facto agreement is going to be a more appropriate one?
Okay, so I'm going to deal with your questions very quickly because I want to also deal with some of the ones that have been asked. But first, the consensus in the AfCFTA about when the appellate body of the panel exceeds the timeline, that is silent. So it hasn't, it's not in the treaty. We don't know. Maybe there's still obviously working procedures that are going to be developed. And maybe, as in the dispute settlement system of the WTO, the working procedure of appellate review is a separate document that is not part of the DSU. And I imagine these issues, if they were to be addressed, could be addressed in the working procedures, for one. So we don't know in the text as it is. Secondly, the positive consensus of the panel, I think I should mention that is actually silent. So that's why I thought it might have been an omission, because in the adoption of panel reports and retaliation, it states that negative consensus would be adopted, sort of language to that effect. In the establishment of a panel, there was no language. So it might have been an omission, or, it always falls back into the Article 5 that says decisions of the DSB is by positive consensus. So that could be sort of how we read the silence. In terms of arbitration, I think that the ex ante, so before even so let me just give you a bit of background on the arbitration clause. The arbitration clause of the AfCFTA is actually interesting because it states that members can use arbitration as a method before they even go into the panel phase. So if you guys remember the AfCFTA, as I mentioned, they use the arbitration clause of the DSU as a dispute settlement sort of appeal process. So in the AfCFTA, the members can use it before the appeal process. So I think it's a little bit different in that. And they can also sort of use the appeal, mechanism as a whole, dispute settlement, way to resolve the dispute without going to the panel. So obviously you would have to agree before. And I think especially now we see what we know and we see what we've seen, that it is in the members' interest to agree as to how they're going to resolve their dispute right at the very beginning. let's say, for example, they want to go through a panel phase and then go through arbitration. Before the panel is established, probably, or by panel establishment, there has to be some sort of agreement that has to how the decision is going to be appealed, or the next step of the decision. Because otherwise, after that, the responding party or the losing party can say, no, I'm not getting involved. I'm not going to get involved in any sort of appeal or dispute settlement process after this process that we've already completed and I've lost. So I've got a few minutes. Am I allowed to deal with some questions?
Please go for it.
So I don't want to sort of leave people out. I'd at least to sort of say something on what everybody has said already in the chat, because I think it's fair. Siyabonga talks about the fact that FDI comes from outside of Africa, and we know that there's a large, the large international investors seem to bypass the WTO dispute settlement system and opt for private arbitration. Can you comment on how the AfCFTA could handle private arbitration as well as investor? Okay. Investor state dispute settlement system, the majority of African states are smaller. I think we have to also, keep in mind what this thing is. It's a state-to-state dispute settlement mechanism. So the only way that the cases are going to go to the AfCFTA dispute settlement system, like the WTO, is if member states actually take the disputes. Obviously, it does not exclude members, private parties litigating through other means, and it would not be through the AfCFTA. Unfortunately, I mean, there is no sort of way to stop private parties from going to investor states, if they have a bilateral investment treaty with a certain country. So like the WTO does not stop private parties from going through private in arbitration or investor states if they have an issue. And if you guys remember, the tobacco case actually started in investor state. It started in an Australian case, Australian courts. It went to investor state dispute settlement system, and then it went to the WTO. So there were many fora in which this case was litigated. So no, I mean, the AfCFTA cannot stop private parties from resolving their disputes in the way that they want and in the way that they have recourse to. Kolisi says that the crisis at the AB isn't the AB's doing. Had the other organs of the WTO, the negotiating, the political arm, done their jobs, they would not have been faced with this crisis. Yeah, so I mean, I think we've mentioned this before. The appellate body and the panels were faced with an enviable job of doing the job of the legislators, and obviously any issue would go to that function because that's the only active function. And obviously, if there's criticism, it go to that function. If there's praise, it go to that function. So as we've said before, some of these criticisms that the US have now, they've been happily using the system for a long time. And so, yeah, it's just the making. I think it's just how it is right now. The WTO hasn't functioned in the negotiating, functions for a long time. So the political body hasn't been functioning. So I take your point, and I think in that respect, you do have a point. Sia says, thank you very much, Sia. And then there's one of the last, okay, I'm not going to go through all the questions because I think we don't have time.
Please, Kulu, you've already given us your indulgence. Yeah. So yeah, maybe another 10 minutes or so, then we wrap it up, yeah? Okay,
so in 10 minutes, I will finish up in 10 minutes. Okay. First of all, thank you very much for this interactive session. It's very it's great to, to have, interaction and to talk and to exchange views about these things of real importance.
Absolutely.
So Makala says, doesn't trade retaliation go against the, so he says, doesn't trade retaliation go against the principles of WTO? Yes, it does. But remember that retaliation would have to be authorized. So the member retaliating first has to go to the DSB and say, hey, this member has not complied with the time and the ruling in the time that it was supposed to. So I ask for permission to retaliate. So in this case, it's sort of endorsed and allowed retaliation. So yes, you're absolutely right.
Yeah, sorry, Kulu, on that point, and maybe for once again for business people, if you can give them, the example, the difference between the retaliation you're referring to and the one between China and the US over the past couple of months, Just to show the distinction in that, please.
Absolutely, absolutely. So, I mean, we all know about this trade war that's been happening between the US and China. And they've been engaging in what they call retaliation, which is not retaliation in the sense of the WTO dispute settlement understanding. The retaliation is basically them increasing tariffs as and when they wish. When they have grievances with each other, that's how they're dealing with it. This is absolutely different, and this is to the extent that the US or China increases their tariffs, that maybe I'm getting a little bit technical, so let's just leave it at that. So let's go to the retaliation in WTO dispute settlement as a means of, you know, getting some sort of relief. As I said to you, the default position is that you have to comply. But obviously, if a member does not want to comply on time or does not want to comply at all, the other member must not be left hanging, so to speak. And so the DSB will authorize this member to retaliate, basically to rebalance, you know, the trade that has been lost. And they can increase tariffs on the other members, whatever cause, for example, if Germany, you know, the EU, you know, and Canada wants to retaliate against the EU, then Canada will increase tariffs on, you know, Audis and Mercedes-Benz and whatnot, so that the EU can feel the burn, you know, and obviously try to make the EU comply with the ruling. That was a really good question. Okay. So I'll Apollonio has admitted guilt. He was the person that was scratching the slides. So thank you for being honest.
Okay, sorry about that.
Okay, no problem. We have Jermaine and Mishak. If you guys don't mind, I'm not going to take your other questions again because there's some people that haven't asked yet. So I'm going to go to Mwape. Hi, Mwape. So Mwape says thanks. And she says, this triggered my thoughts on what lessons the AfCFTA can draw from the WTO dispute settlement system in the light of COVID-related disputes. This is with respect to the fact that WTO has not been faced. Yeah, so I mean, so far we haven't had any COVID disputes because it's accepted and it's agreed that COVID is a temporary situation. It's an emergency in nature. And so, I mean, to the extent that members have to deal with, you know, the pandemics and the way that they have to, they, you know, sort of given carte blanche to do so. So, you know, of course, if members then start doing things that are not WTO consistent in the name of COVID, then that might be an issue. Tapano says thank you. And the question is, in your view, do you think decisions that will come from the AfCFTA will be respected? Ooh.
Very good question. Yeah,
that is a very good question, especially as you said, in the light of what happened in the SADC tribunal, which is now defunct. I mean, right. As you know, your guess is as good as mine. I mean, if members have taken the time to negotiate this agreement and they spent time and money and resources and brain power to do so, we expect that they will comply with the rulings. We hope so. I mean, this is a rules-based system that we've all signed up for, so we really hope. So we hope we don't see what happened at the SADC tribunal. And then finally, Situmo. I think it's another question from Spino, but you get a free.
Let's do that.
So yeah, okay. So I think we have completed the questions. I'm sorry for not repeating those that have asked questions before, but I think it's fair.
Fine. Thank you so much. Thank you so much, Kulu. Colleagues, thank you very much for your participation and for your questions. Kulu, to you for your time and indulging us with your presence. We're truly grateful to that. And I hope this is the beginning of many, many more sessions we'll have. I'm looking forward to some of our colleagues on the platform inviting us as well to their sessions to share the ideas, because as you've seen our hashtag Accelerate AfCFTA, that's what I believe in. The only way we're going to get out of the ghetto is to accelerate trade amongst ourselves. And yes, I will, make a short summary, and only people who have signed in will receive a copy of the video upon request. So if you do want it, please do ask for that. And Kulu, wow, round of applause for you again.
Thank you.
I know the kids are probably asking why is mommy or daddy clapping hands, but I think it's you can only thank someone really that much. So we thank you. Warm African greetings, Kulu.
Yes. Thank you. It was really a pleasure. Thank you so much for your time and your indulgence.
Yeah.
And as Ronnie said, I hope this is just the beginning. Let's share with each other knowledge. Let's you know, expose each other, and let's make Africa great again. Huh?
Thank you kindly, and walk safe to your dining rooms or wherever you're walking to. Thank you so much. What a wonderful time we're living to be able to host
Bye-bye.
parts of the world. Thank you, colleagues, and good night.
Take care. Bye-bye.
Goodbye.